Hello, good afternoon, everybody. Thank you for carving out some time to join us here today. Hopefully you are all here for the All About Trust webinar. If you signed up for the Microsoft Excel for Dummies or basket weaving for beginners, you're in the wrong webinar. This is All About Trust with Fort Pitt Capital Group. So just want to make sure everybody's in the right place. I am very excited because trusts are awesome, and there is, I think, a lot of interest in talking about trusts and how they can help. But this is actually the so we do these webinars every 2 weeks or so, and we've been doing them for a while. But this webinar is actually the most registrants that we've ever had. So thank you all for joining us, and it's a little bit of a competition here inside the walls of Fort Pitt of who can get the most folks registered. So you guys made me the winner, so I appreciate that. Anyway, so we will take about an hour or so today to go through some of the topics that we have to discuss. Let me start by just kind of talking a little bit about Fort Pitt Capital Group if you're not familiar with our firm. Fort Pitt Capital Group is a investment manager that we are fiduciaries for our clients, which means we have a legal interest, or excuse me, a legal obligation to always do what is in our client's best interest. Some of the things that separate our firm from some of the others in our industry is we do have a in-house investment management team that handles all of our clients' investments in their accounts. We do like to say we have a boutique feel because we are somewhat of a smaller firm as far as number of employees. However, we have all of the resources of the much larger firms. So it's really kind of a win-win for our clients when you get that personalized connection, but also all the resources of a much bigger firm. So regarding our webinars, as I had alluded to a minute ago, we do these every couple of weeks or so on a host of different topics. We've done webinars on healthy eating and a number of different things, most of which we try and focus on things regarding your financial life and those types of topics that are important to our clients. So if you're ever interested in looking back to some of our previous webinars, they are all housed on our website. So you can go through and look and see what some of the past webinars have been, and take some time and replay those and hopefully find some good information out of that. So a little bit on myself here. I am a financial advisor here with Fort Pitt Capital Group. Well, I guess I should say my name is Chuck Mattiucci, financial advisor with Fort Pitt Capital Group. I have been with Fort Pitt for going on 7 years. I've been an advisor for going on 15 years. My focus is really dealing with individuals and families, helping those folks build a plan for whatever their financial goals may be, whether it's getting to retirement, wealth transfer, funding education for your kids, anything kind of within that range of different topics, working with our clients on and really just kind of being your one resource for anything financial. Am I busy, or excuse me, how I keep busy outside of work? Very easy answer to that. I have 3 young daughters, so that keeps me very busy. I used to play golf. I used to go to the gym. I used to do a lot of stuff, but now with 3 young daughters, I don't get to do that stuff as much. So today I am joined by Ted Simpson with Focus Fiduciary Solutions. Ted has been a great resource for us, and we're really excited to have him here today. A little bit about Ted's background. Ted received his bachelor's in government and pre-law from East Western University, his JD from Gonzaga, and his Master of Laws in Taxation from the University of Washington School of Law. So Ted is very well versed in the estate planning realm of topics, and I'm really excited to talk with him today and really go through some of the high level different criteria that focus on trust. And we thank all of you that provided us with questions prior to this webinar, and we're going to do our best to get through all of those questions. As you'll see here on the next screen, you can also ask questions live as we're going through the webinar. You can see here on the slide well, actually, I'm sorry, this is for handouts, which we don't have any handouts for this particular webinar. However, if you want to ask a question, you can follow along the side there where you see that question mark, and go ahead and type in your question. We'll do our best to try to get to the live questions. We do have several questions to go through today. So if for some reason we don't get to your question, either that you provided prior or that you provided to us during our time today, we do commit that we will get back to you within the next day or two to make sure we get an answer to your question. So with that being said, Ted, welcome. Thank you for joining me today. And we have, in preparation for this webinar, we've talked a bit, and really excited to kind of go through and get your view on some of these questions that some of our participants have asked today. So thank you so much for being here. We really appreciate it.
It's good to be here. Thanks for having me.
Sure, absolutely. So when you and I talked a week or so ago, really trying to find out how do we kind of start this conversation off? What's a good way to kind of kick it off? And you had a great suggestion, which was really talking about how does property transfer at death?
Yeah, I think that sets the stage for a conversation about trusts, but even just a conversation about estate planning altogether. First, though, let me say to the audience listening, everything I say should be construed as education and not as legal advice. So that being said, there are three ways that property transfers at death: by operation of law, by contract, and by probate. And it goes in that order. I'll give you examples of the. So operation of law would be pretty much any jointly held asset, whether it's joint tenancy with rights of survivorship or tenants by the entirety. Any jointly held asset like that, whether it be an investment account or a house or a car, whatever, at the death of one of the owners, it automatically, by operation of law, becomes the property of the other owner. Okay, so that's operation of law. The next thing is contract. A contract is pretty easy. It's anything with a beneficiary designation. So life insurance, retirement plans, trusts, those are all contracts. And then the third is by probate, which is what your will controls. So as an example, and by saying it goes in that order, operation of law, contract, probate, if, for instance, I write in my will that I want to give my half of my house to my brother on my death, but my house is owned with my wife as tenants by the entirety. So when I die, my wife can simply walk into the county clerk's office or county records office with my death certificate, and they will transfer the deed over to her name. And then when my will is probated, which of course it won't be because I'll avoid probate, but if my will is probated, my brother wouldn't get anything because my wife had already taken that half of the house by operation of law. So it's very important to understand how property transfers at death, and so that as a person is sorting out their estate plan, they can they understand how property transfers and they can plan accordingly. Most people think that everything transfers by will, and it simply is not the case. As a matter of fact, most property that most people have does not transfer by will.
Great. Yeah. Thanks, Ted. And that brings up a good point too. Something that we try and work with our clients on, with kind of a very high level with estate planning is just proper titling for certain things. And we see that a lot. We see this a lot where for no particular reason, no particular strategy, husband and wife don't have certain things in joint name, where if it were, that kind of alleviates a lot of headaches down the road. And I mean, unless there again is a particular strategy for that. So I think that's kind of like the first step, at least from our view as advisors, is just really making sure that the titling on things are correct before you even kind of move further into other areas such as trusts.
Yeah, there isn't necessarily a right or wrong way of titling assets. It's just a matter of being purposeful about it, right? So we want to make sure that all of our assets that we want to be held jointly, so that they transfer automatic on death, are held properly that way. And it's the same thing with the beneficiary designations. We want to be purposeful in that. There's no necessarily right way to do your beneficiary designations. Everyone does them different, but we just want to be purposeful and thoughtful in how they're done to make sure that everything's going to transfer the way we want.
Great. Okay, so this I'll throw this next question out to you. What is the basic definition of a trust, and who are the parties or individuals that would be involved in a trust?
The basic definition is simply that a person is going to own property for the benefit of another person or people. That's pretty much it. And it's so that person that owns the property is the trustee. So the trustee technically owns the property, and that trustee has a fiduciary responsibility for the beneficiary. So the parties are the settlor or grantor of the trust. That's the person who's going to put the asset into trust. The trustee, the one who is going to technically own the property and administer the trust, and then the beneficiaries, those who have a beneficial interest in the trust. And those beneficiaries are divided between current beneficiaries, sometimes known as income beneficiaries, and then contingent beneficiaries, the beneficiaries that could take an interest later. The trustee owns a fiduciary responsibility to both the current income beneficiaries as well as to future contingent beneficiaries.
Great. And essentially the actual trust itself is basically illustrated through a document that would basically explain what the grantor or settlor wants to happen with the assets. Would that be correct?
Yeah, I mean, technically there doesn't have to be a document, because there can be something called constructive trust. If I were to say, hey, listen, I'm going to give you this property for the benefit, and I want you to hold it for the benefit of my daughters, and we don't put a document together, that would be a constructive trust. There isn't necessarily a document in place, but that's a horrible idea, right? We always want to have a document in place that details all of the information about the trust and how it's to be administered.
Right. Great. So I think there's and hence I think the reason why we have so many folks joining us today and so much interest in this topic, I think there is a lot of confusion about why to use a trust or when to use a trust or what have you. Some people I've heard say that I'm going to put my money in a trust so nobody has to pay taxes, or, you know, whatever the case may be. And, you know, that's, you know, maybe not necessarily true, but could you maybe just touch on a couple of the main benefits of a trust that, you know, that you've seen in working with clients?
Yeah, first off, there are a number of reasons people might use a trust, and each one of these reasons stand on its own, right? So you don't have to have all the reasons. Any one of the reasons could be enough reason to use a trust. The most common reason people will use a trust, and frankly, what trusts were first created, was the spendthrift provision. So I leave assets in trust to my children because I don't trust my children, right? To make wise financial decisions. And so I want to appoint a trustee that's going to make decisions for and on behalf of my children. Now, even if I trusted my children, you know, my wife has raised our children to be, I might have had a little to do with it, but to be productive, responsible financial people. And so even if I totally trusted my children, I still would want to leave those assets in trust because I don't trust everyone else. There's no better asset protection vehicle you can have than a trust set up by your parents. The most common creditors our children are going to face is unfortunately future ex-spouse, a tort action. So if they're involved in an accident or injury and they're somehow held culpable, or if they are entrepreneurial and they have to go through a bankruptcy. Any of those three situations, assets held in trust set up by the parents are not subject to the creditors of any of those claims. So, so for spendthrift, because I don't trust my children, for asset protection, because I don't trust everyone else. The third most common reason is taxes. You said that earlier. And it's not just a tax, it's all kinds of taxes. So we use it for income tax shifting. We use trusts for capital gains deferment. We use trusts for estate and gift tax purposes. So we use trusts for all different types of tax reasons. Also, trusts are used for the pooled management of assets. So let's say we have a family farm and we have you know, I have 5 kids, and if I were to leave the family farm to 5 kids, you know, they might, you know, have a difficult time, you know, they have a difficult time getting along anyway, but if there were all 5 were trying to manage a farm, that would be difficult. So I could leave it in trust. The trustee manages the farm for the benefit of the 5 kids, right? So pooled management of assets, and then probate avoidance is another common one. You know, we talked about the 3 ways that property transfers at death, by operation of law, contract, and probate. To the extent that you want to avoid probate, and there's a lot of good reasons to avoid probate, that you can simply move those assets from the probate section up to the contract section by creating a revocable trust and titling those assets that would otherwise fall into probate into the revocable trust, and now they will all pass by contract. If you don't have any assets to fall to probate, you just don't file or you don't because you're passed, but your executor just wouldn't file a probate. And so you avoid probate that way.
Right, right. Great. And something that you touched on first, the spendthrift situation. So, you know, say that is an example where, you know, somebody is concerned about, you know, their children inheriting all of this money and blowing through it. You know, there are certain, and actually, I mean, I guess you could really put whatever you want in a trust as far as instructions, but you know, there's certain things that you can do inside of the trust in this spendthrift situation where, you know, my child can access X amount of, you know, the assets at this age, X amount at this age, or they can get income from, you know, from the trust up until, you know, this point. Is that correct? And if you know,
well, yeah, first off, I would say one of the things, I review thousands of trusts every year, and one of the things that I find disappointing, frankly, is that the words of the trust document are the words of the lawyer, not the settlor of the trust. You know, we should speak. I mean, the whole point of a trust is to make you immortal. These are the decisions you would be making if you were around, right? And And so what is it that you want to do for the benefit of your children? And so you can have provisions into what things you want to pay for. If you want to have, for instance, a wedding gift, you can put that in there. If you want to, if it's your goal to help your children with a down payment on the house, or to start a business, or to pay for their education, or whatever, you can put those provisions in the trust. You can also include provisions like income matching, right? So if you want to, if you don't want your kids to be trust fund babies and just live off the trust, you want them to work, you can put some sort of income matching provision in there. You can get pretty creative as to what you put in the trust to motivate your child. We call this dead hand control, or you reaching up from the grave and controlling the situation left behind. But it can be very powerful. Now, I will say, every time I see provisions calling for distributions at set ages, I always cringe a little bit, because no one has a crystal ball to know what your children are going to be going through. And if you have a forced distribution at age 35 and your child is going through a divorce at age 35, you're going to throw all of those assets into the middle of that divorce, versus, if there isn't forced distribution, if there's discretionary distributions that the trustee has, then, you only take money out of the trust when needed, and you still have all the asset protection components.
Right. Great. Thank you. So you talked a little bit about revocable trusts. Can you just give us a quick overview of the main differences between irrevocable and revocable trust, and where you might use one and where you might not use the other?
Yeah, so a revocable trust is as the name implies, is you can revoke it. You can say, I don't want it anymore, and unwind it. The most common use of a revocable trust is the living trust, which is a probate avoidance technique. Most other trusts are irrevocable, in that once you set it up, you can't just easily unwind it. Now, that being said, there are a number of ways of changing an irrevocable trust. So irrevocable doesn't have the meaning it used to have, but depending on the state that you're in, because state law really controls this issue, but you can what they call decant the trust, which is take the assets of one trust and pour them into a new trust and change the terms of the new trust. You can do non-judicial settlement agreements to change a trust. You can, if not all the parties agree, you can do a judicial settlement agreement to change the trust. Sometimes you might have an individual in the trust, sometimes called a trust protector, that has the ability to make changes to the trust. So there are a number of ways you can change an irrevocable trust. We still call them irrevocable, though.
Right. And not to get too far down a rabbit hole with the types of trusts, but I think, I guess in my experience, and you may agree or disagree, irrevocable trusts are used more for, we explain it to clients like, if you're doing a irrevocable trust, that's, you're giving up control. That's something that you're willing to just kind of give up the control on. Whereas, a revocable trust, you can make changes, you can unwind it, as you mentioned. You have somebody listed in there as a beneficiary, and they make you mad or cross you or something like that. You can change that. So that's I think when we talk really high level, those are kind of like the main points that we touch on with the differences. So what would you say, I guess, beyond just, the irrevocable and revocable trusts, specific types of trusts that are maybe most popular? I know there's a bunch of different types of trusts with a bunch of cute acronyms that, that we use, but, maybe touch on a couple of those and what some of the characteristics are.
Sure. So the most common trust is the revocable trust, or revocable living trust, which is the probate avoidance technique we talked about. That's by far the most common. Probably the next most common trust is a irrevocable life insurance trust. We call it the ILIT, I-L-I-T. And the reality is, if you own a life insurance policy on your own life, when you die, the proceeds of that policy are included in your estate for estate tax purposes. So to the extent that your assets are already meet the lifetime exemption amount, that the insurance is going to be taxed at the current rate now is 40%, the insurance proceeds. So in order to avoid that, you can establish an irrevocable life insurance trust and then have the trustee of the trust buy a policy on your life, and therefore you don't own the policy technically, and those insurance proceeds are not included in your estate. So the irrevocable life insurance trust is probably the next most common type of trust. Beyond that, generation skipping, transfer tax. So if you want to leave assets to your grandchildren, and so they're not going to pay an extra layer of tax, people will set up generation skipping trusts. Spousal lifetime access trusts are very common right now. People who are trying to use up the exemption amount, the current exemption amount, $12,920,000, is set to cut in half at the end of 2025. If you use the exemption amount before it cuts in half, then it's preserved if you use it appropriately. And so a lot of people are setting up spousal lifetime access trusts. So they're basically, you put it in trust for your spouse, your exemption amount in trust for your spouse, so that you technically get it out of your estate. However, as long as you stay married to your spouse, you still have access to it. Other ones that are common, qualified personal residence trusts for your house, grant or retain annuity trusts. Special needs trusts are common. Charitable remainder trusts are common. So there's lots of trusts out there. Defective grantor trusts. There are a lot of different trusts, and each one has its own little reason for using it.
Great. Yeah, and I think that's the thing that I think could be a little overwhelming, for folks is, if you start looking into this stuff, and there's all these different kinds of trusts, and what do all these mean? I think probably the best thing to do is, if you think you're in a situation where a trust makes sense, sit down with a professional, an estate attorney, or what have you, and really kind of go through what your desire is for your assets, and then
So I think of the trust as a roof, right? You don't start building a house by building the roof, right? You build the walls first, and the walls there are 4 walls to your house. There's the family, your assets, what we call testator's intent, which is really just your goals vis-a-vis your assets and your family, and then the law. So those are the 4 walls of the house. Once you have your 4 walls built, then you can put the trust on, right? The roof on the house. So that's really the starting point, is sitting down with your advisor and talking about, your family and your assets. What are your goals with your assets vis-a-vis your family? Because not everyone has the same goals. And then the law, hopefully the advisor will provide the law part. You don't need to. And then you're in a situation to discuss, okay, which one of these trusts makes sense to us? I would not start out by saying, I'm going to learn everything about all these different types of trusts, because most of them are probably irrelevant to you. So you start by building the walls, getting sit down with your advisor and get a clear understanding of those 4 areas, and then it'll frankly just be apparent what are the trusts that are appropriate.
Right. Great. Thanks, Ted.
Mm-hmm.
So this was a very popular question that came through from some of the folks. Can you provide a ballpark cost for setting up a trust?
Yeah. Yeah. Look, I would say on the low end, you know, a couple $1,000 on the low end, and then on the high end, it can go up to, you know, $10,000 for a trust. That being said, I generally have a rule of thumb that if you take all of your assets and combine up all your assets, your estate plan, if the estate plan, doing an entire estate plan, not just a particular trust, but an entire estate plan, it should be about 10 basis points of your assets. That's, now there may be reasons it's going to be more and there may be reasons it's going to be less, but that's kind of that comfort zone that I look for in what are the fees that someone could expect to pay. Yeah, these are complicated documents, and they should be, frankly, because you want all the protections that are available to you in the law. So, you know, I would say on the low end, yeah, about $2,500, and then up to, you know, 10,000 or more if you're, some of these more complex trusts can get, you know, can
Right.
be more.
Sure, yeah, absolutely. And I think that, you know, that comes back to, you know, depending on what you're trying to achieve and, you know, how much work is going to go into that. Obviously, that's going to cost a bit more. If you're doing, you know, probably more of a simple type of, you know, revocable trust, the probate avoidance type of trust that you were mentioning, that's probably, you know, not going to be as much work. So yeah, I think the general, you know, the general idea there is, you know, in that ballpark, a couple of $1,000s on the low end, but, you know, could be, you know, significantly beyond that, depending on, you know, what type of work goes into it and what you're looking to do. And again, too, I think, you know, I can speak for, you know, for our clients, you know, here at Fort Pitt, we do not have attorneys on staff, so we don't draft documents. We say that we advise our clients on estate planning, which we do, but we don't draft documents. We try and gain an understanding of what a client's trying to achieve, and then kind of make some recommendations. And at that point, involve a third party, you know, attorney, professional that can handle all of that. But, you know, we can a lot of times help clients get an idea of, hey, here's what you're looking to do. It's not super complicated. Here's kind of what your, you know, ballpark is going to be. All right. Well, thanks. I appreciate that, Ted. The next question that I wanted to throw out there to you is, and you talked a little bit about a property trust, but so how does that work as far as, you know, putting property into a trust, you know, such as a home, and, you know, why would somebody do that? Can you give us some kind of background on that?
Sure. I mean, there could be a number of reasons why someone may want to have their home in a trust, and frankly, there are reasons people don't want to have the home in a trust. I'm in Florida. Here in Florida, you know, people may put their property in a revocable trust. Many don't. We have pretty good law. First off, we have the Homestead Act, which you know, so the property transfers by operation of law under the Homestead Act. Also, if your house is owned as tenants by the entirety, there's an asset protection component there as well as it transfers by operation of law. So frankly, a revocable trust in that case might be redundant. But you know, that only covers on the first death. And so on the second death, you know, you may want to have the house in trust, in the revocable trust for that purpose. And then the other trust that's commonly used with your home is the qualified personal residence trust. And that's a way of transferring the trust down to the next generation at a discounted value. So you put the property in trust. During the term of the trust, you get to live there rent-free. After the term of the trust, the property transfers to the next generation. And if you're going to continue to live in the house, then you're going to have to pay fair market value rent to stay in the house. But it is a way of transferring that down and getting a discount on the transfer, because when you make the transfer, the value of the gift is, you know, you subtract your use of the house during the term of the trust. And so the value that gets transferred down is the discounted value, plus it locks the value in place. So if during the terms of the trust the value doubles, or the house values doubles in value, then you're still locked in at that amount, that discounted amount when you first set up the trust. The downside of a qualified personal residence trust is if you die during the term of the trust, the house is included in your estate, even the appreciated value of the house. So you don't want to do a qualified personal residence trust that's too long. You want to make sure and outlive the term of the trust. But it's a great way of removing the asset, that big asset, out of your estate.
Great. So one thing that we've gotten questions on, and even as we're taking some live questions here as I see them coming through, folks are, and I know there's a whole kind of separate discipline within estate planning that focuses on what's called quote unquote elder law. But there's been, I think, a lot of information out there about if you have to go into a long-term care facility, and you spend through your assets, your home could be taken and different things like that. So there's been talk about how to avoid that from happening, and can you protect your home if you go into a long-term care facility. So I don't want to, I know that's not your specific focus as far as elder law goes, and not ask you to go into a lot of detail on that, because that could be a whole another topic. But can you maybe just give us kind of like a quick overview of what you know about it?
Sure, but first off, one more thing I wanted to say about transfer of home to trust. Another common way, the reason people would use a trust for a home is a vacation home. So if they're planning on leaving, they want to keep that family vacation home in the family, they'll commonly leave it in trust. And that way, you have the trustee is going to manage the asset, and you don't have the children necessarily fighting about the use and the management of that house. So that's another reason people use house. With regard to people that are going to a long-term care facility and they're planning ahead of time, that you are correct, Chuck. It is not my area of expertise. There are a lot of attorneys out there. They're called elder law attorneys. This is their area of focus. My suggestion is that someone should talk to an elder law attorney and get their estate in order for that, because there's timing considerations there. You cannot do that planning, a week or two before you're going to go into the facility. You have to plan well in advance, even 3 to 5 years in advance, in order to set up the estate appropriately so that your estate assets do not get drained by the cost of the long-term care. So there are strategies one can put into place. Some, frankly, are more palatable than others, but still, there are strategies one can put into place to protect the family estate in case you have the unfortunate event of having to go into one of these facilities. But I would just say that strongly encourage people to go talk to a elder law attorney to sort all of it out. There are a lot of rules that and it's the federal government is involved there with the Medicaid, and they frankly want their pound of flesh, and so that's why you need to be very careful in how you do this planning. What happens oftentimes is people that don't do the planning ahead of time, they do what I call desperate planning, on the eve of it, and that's where, like, for instance, they're trying to I've seen people like get divorced right before they go in, and in order to try and move assets around. But those are, most of the things that you were able to do years ago, you can no longer do. They've plugged most of those holes. So careful planning is very important in this area.
Yeah, absolutely. I agree. And, that's something that we try and, consult our clients on, even from, when we first start engaging, with a new client is, talking about these things that may not come to fruition at all, or not for a long time down the road. But, I've had this happen, at least several times, with clients that are wanting to put their home and different things like that in a trust, so that to protect from a long-term care facility. And what we kind of start with is let's look at what if you did go into a long-term care facility, or your spouse, what does that cost? What's the average stay in a long-term care facility? And then you kind of look at the assets and say, okay, if it's going to cost $120,000 a year, and the average stay in a long-term care full care facility is 18 months, your portfolio a lot of times in certain situations can sustain that and still leave money to the surviving spouse. So people want to kind of do all this stuff when it may not be necessary, but it is necessary for some folks. And again, like we mentioned, there's professionals that deal just in that particular area, that would be able to help. So thank you, because that's definitely one that we get a lot. Another just kind of quick question on a specific trust is a special needs trust. If somebody has a disabled child, or something like that, and they're concerned that when they pass, that that child is still taken care of. And how do special needs trusts kind of work as far as that goes?
Yeah, so there are two kinds of special needs trusts, a first party and a third party special needs trust, and I'll talk about both. But the main consideration here is, and I get a lot of this, is people will call and say, I have a disabled child, I need a special needs trust. But you need to dig into this a little bit, because just because a child is disabled or has special needs doesn't mean they necessarily need a special needs trust. It's only those that are going to qualify for disability benefits, so SSI and Medicaid, that if they would otherwise qualify for that, except for the trust, then they need a special needs trust. Otherwise, they just need a trust. So, because there's a lot of it's not easy to qualify, right? There's a lot of people that one would consider is disabled, but wouldn't qualify for SSI. So that's the threshold question. And I'll get an example is, well, first off, let me give you an example from my own life. I have a sister who has Downs. And when my parents initially applied for SSI for her when she turned 18, she was denied. And it took them 10 years of appeals. So if you think of, and she has the mind of about a 9-year-old. So if you think of, the level of disability that different people have, then, it's not just a foregone conclusion that people are going to qualify for SSI. If you don't qualify for SSI, you do not want a special needs trust, because the special needs trust says, do not take care of the everyday needs of my child, just their special needs. If they're not going to qualify for SSI, you want the trust to take care of their everyday needs. An example I get, a most common example I get, is they want a special needs trust because the child or grandchild has autism, and the range of autistic children is pretty dramatic. To some who can't speak and can't work, to where there are others that frankly can operate just fine. So frankly a good percentage of children with autism are not going to qualify for SSI. So that's the threshold question, is are they going to qualify for SSI? Now, on the first person, third person, the first person special needs trust are for people who typically, because of an accident or injury, but they become disabled and they already have assets. They can put those assets into a first-person special needs trust, and then those assets are available. They're still going to qualify for government benefits, and their assets are available for their special needs. But when they die, then the government gets reimbursed out of the trust for the benefits the government paid out on behalf of the individual. A third, that's a first-person special needs. A third-person special needs trust is where parents or grandparents set up the trust for a special needs child. In that case, when the special needs child dies, the government is not reimbursed for the benefits that they paid for the special needs of that individual. And the assets can go to the family members or whoever according to the terms of the trust. So yeah, so that's I guess the nutshell of special needs trusts. But again, the threshold question is the individual going to qualify for government benefits?
Right. Yeah, and I think what it sounds like is with some of the other types of trusts that we were talking about, it's very situation specific, based on the particular individual involved and what we're trying to achieve. So thanks for that, Ted. One thing I did want to touch on is I think what I've seen in talking with clients who are looking to set up trusts, one of the hesitations that they have or concerns that they have is selecting trustees. So the trustee is responsible essentially for doing what the trust says. And a lot of people want to use their brother or one of their friends or what have you, and that can be a pretty significant responsibility for that person to undertake, and then you have folks who don't really have anybody that they really feel confident in electing as a trustee. So I wanted to see maybe if you could just briefly kind of talk about the role of the trustee, and then also about using corporate trustees. I know in some clients that I work with, we used corporate trustees that act in that capacity. So just wanted to see if maybe you could share a couple thoughts about that.
Sure. Yeah. So again, no right or wrong answers in how someone who someone chooses to be a fiduciary of their trust. It's very fact specific in their situation. But I will say, by and large, one thing I see, the issues that happen is like people, for instance, they'll say, I'm going to have my sibling serve as trustee. The reality is your sibling is close to your age. And, and if you live to life expectancy, when you die, your child or your sibling is probably also close to their life expectancy. And so, that's probably not the best solution in that case. Then I see a lot of people who will say, for instance, the oldest child will serve as trustee. And I've seen that not work out very well in a lot of circumstances. Sometimes it does. And I have clients that have said to me in the past, "Oh no, my family's different. My children get along." And I would say, oftentimes, yes, they get along because you're around. And when you die, you're no longer around. And oftentimes, the situations where the oldest child is trustee ends up in litigation. So then you say, well, okay, I'm going to make all of my kids trustee as co-trustees. Frankly, that oftentimes is worse. Because it's people have selective memory, and so oftentimes people will say, well, I talked to dad and dad said this, and I talked to dad and dad said that. And it very well, dad could have said both, because either he doesn't remember what he says from one child to the next, or people hear what they want to hear. Or remember what they want to remember, and those things can often cause problems. The other thing is administering a trust is there's a lot of rules and every state has their own set of rules around how trusts are to be administered. And there's a lot of technical terms with regard to trust, and trusts have certain requirements, both federal tax purposes and state law purposes with regard to reporting. So you have to make sure that whoever is going to be trustee is going to comply with all of that. And then finally, having a trustee is like having an insurance policy, right? Remember, we talked about earlier that a trustee has a fiduciary responsibility to the beneficiaries, both current and contingent beneficiaries. With that fiduciary responsibility comes fiduciary liability, right? So if they mess up in the administration of the trust, whether it be the investments, distributions, or the following the administrative rules with regard to the taxes and the reporting, if they mess up in any of that, they're liable out of their own pocket to reimburse the trust. So one of the things is you think about is the person you're selecting as trustee, do they have a deep enough pocket to make the trust whole if they have an error in how they administer the trust? You know, and the answer may be yes, and that's great. But if not, then that's where you might want to look at a corporate trustee who's an unrelated party and is a professional at managing trusts and have deep pockets, either because they just have a lot of money on hand or they have insurance that covers them if in case they mess up in administering the trust. So. And I will tell you, there's lots of different types of corporate trustees. There's also professionals that serve as trustees. A lot of attorneys or CPAs will serve as trustee. There are, in some states, professional fiduciaries. So it's not a trust company, it's just an individual that serves as a trustee. So there are a lot of options out there. And again, not necessarily right or wrong answers. It's just you want to find the situation that fits your family the best, and I think that starts with a discussion with your advisor and just say, hey, listen, let's talk this through. What makes, based on my family, based on my level of assets, based on the tenure of the trust, based on all these different things, what makes the most sense for my family? Another issue is a trust is situs, or like lives, its domicile is where the trust is administered. So oftentimes for tax reasons, you may want the trust to be sitused in a jurisdiction that doesn't have an income tax, because then there could be some tax savings on behalf of the trust. So in that case, you're going to want to pick a trustee that lives in a state that doesn't have an income tax. So choice of trustee is a very important issue, and it certainly should be near the top of the list when you start talking about drafting a trust.
Great. Yeah, absolutely. Yeah, I think that's quite honestly one of the biggest hurdles that that I've noticed with clients who want to set up a trust is figuring out who do we elect as trustees. And frankly, a lot of times I say, look, if you have second thoughts, or you're not feeling so good about whoever it may be, relatives, whatever, then maybe that corporate trustee, somebody who solely serves in that capacity and has experience doing this, is the right way to go. However, you have to consider as well that nobody works for free. So along with that, is a fee that comes along with that as well. But again, yeah, to your point, Ted, it just kind of really depends on what on the individual situation. So. Thank you. So we're bumping up against 1 o'clock here. I did want to take, there were several questions that came in that I want to just catch a couple of them, and then if we do not answer your question that you've submitted, as I mentioned, we will get back to you and follow up and get an answer for you. The first one I wanted to tackle here is, and I might be able to kind of start the answer to this, and then you could jump in, Ted. What are the negative aspects of probate? you know, as the way I see it, you know, when talking with clients, I guess the big drawbacks, if you will, of probate are cost, fees, time, and then privacy, right? So, you know, there is a cost for probate, you know, depending on your jurisdiction or you know, wherever, you know, you're going through probate, it you know, could take a long period of time, you know, to have that assets go through probate, which prolongs that money being distributed and those assets being distributed. And then also when it goes through probate, it becomes public record. So, you know, if you don't want people to know, you know, anything about your assets or what have you, you know, that's something that probate would disclose. So those are the three that I always think of. Ted, anything else beyond that?
The only other thing I would say is if you have tangible property in more than one state, then you'll end up probating in more than one state. So the cost issue gets compounded in that circumstance as well. So, but you hit the main points. You know, certainly cost, duration. Probates can last. A common probate is a year-long process. I've seen probates last, you know, 3-5 years. And I mean, they can be shorter and sometimes are, but most of the time a common time period is a year. And you know, the whole time you typically have an attorney involved that's billing, you know, billing for the time. So it can get expensive. Some of the onerous problems with probate don't exist anymore, right? It used to be there were no interim distributions. So, you know, husband would die, all the assets were in his name. The wife and children couldn't get any distributions until the entire probate process was wrapped up. In most jurisdictions, that doesn't exist anymore. You can do interim distributions. You know, so there were a lot of old draconian rules that no longer exist. So and they're also in a lot of jurisdictions, if your estate, or not the whole estate, but if the probate estate is smaller than certain amounts, then the process is sped up considerably. But nonetheless, it's at least it's a good idea to avoid. On the privacy issue, the thing to keep in mind is so you basically filing a probate is like filing a lawsuit, and a file is built at the clerk's office, and anyone can walk in and pull that file and look at it. The two things there's a bunch of things that are going to go in that file, but two of the things that go in that file, number one is a copy of your will. So if your will has the dispositive provisions in it, people are going to know who's going to get what assets. And the second thing that gets filed is the inventory of your estate. So someone can pull it, they can see every asset that you have and who's going to get those assets. And there are people that, frankly, that's their full-time job, is going through probate files. And they're looking for, like, you know, maybe they're a collector or something, and they're just looking for estates that have certain collections. And they start pouring through these inventories looking for those assets. So yeah, it's and then reporters go in. If you're famous and you die, then they try and pull the probate thing just to get dirt for articles. But it's a common thing. I think most people should want to avoid probate. The one thing that probate does do is it cuts off creditors. So you know, after that 3-month period after publication, then if creditors don't crop up, they get cut off. So there may be people like lawyers and doctors and some business people that may want to go through probate, you know, just to cut off creditors. Or if the state has another method for cutting off creditors outside of probate, they could do that too. But so again, with everything that we've discussed, and this included, it's always a good idea to talk to legal counsel about your particular situation, and you know, and don't just take something said like, oh, everyone should avoid probate, and so you avoid probate too. Every aspect of these things should be considered vis-a-vis you, your family, your assets, and your testator's intent.
Great, excellent. Okay, so we are at 1 o'clock now, so I know we probably have some folks that need to get back to work or have just this much time allotted. So I would say I think the big thing here from my seat with how I work with my clients is reach out to your advisor, and if you don't have an advisor, give us a call. We're happy to help. But that's kind of a starting point, is to talk to somebody like us who can really look at your assets and your situation and ask some questions and try and identify what it is that you need to or what it is that you're looking to achieve, and then kind of point you in the right direction. Like, hey, for what you're looking to achieve, we do some titling, we do a simple will, power of attorney, medical directive, and then you're all set. Or maybe we do need to consider a trust because you have certain other things that you're looking to achieve. But I think that's a good starting point. And then at that point, we would pull somebody in, like Ted, to talk about the actual nuts and bolts of doing that, and they're more of the expertise when it comes to the actual estate planning. So Ted, I really appreciate your time today, man. It was great. I think we covered a lot of content. Hopefully, everybody enjoyed the time that we had, and this is a popular topic. So I think we may have to do something else like this again in the not too distant future. Maybe focusing a little bit more on certain types of trusts or something like that. So we'll have to put our heads together and see what we can come up with. But really appreciate it. In closing, just want to give you folks a heads up about our upcoming webinars. So we have another webinar on May 24th, which is maximizing your military and veteran benefits. And then June 28th, all about insurance. So 2 really good webinars coming up. And if you registered for this webinar, then you will get an email with instructions on how to register for these other 2 if you're interested. Again, you can always go to our website and view these webinars again. And again, we really thank you for your time and appreciate it. And again, if we didn't cover your questions, we will follow up and get back to you. And thanks again for your time, and I hope everybody has a great day. Thanks, Ted.
All right. Thank you, Chuck.
Oh, I'm sorry. One more slide. This is an important one.